Yeah, come on over here.
Good afternoon, everyone. We're going to start in just 1 minute. All right, 2 o'clock on the dot. Welcome to today's webinar. Hope you are enjoying Sunshine Week wherever you are. We're doing these webinars every day this week at 2 o'clock. And today we have a really interesting one. Before I get into that, let me introduce my colleagues. We have George Spiess, who's the Chief of Outreach and Training. You've probably heard his voice before if you joined one of our weekly webinars. And we have Nathan Byerly, who's our Deputy Executive Director here. And we're going to be talking about what we have dubbed trending issues. We at the Office of Open Records have experienced 2 consecutive record-breaking years in terms of the number of appeals that we have received. Last year, almost 3,000. And it's not too hard to discern why when you look at a lot of the subjects that we are, matters we are seeing in the records requested. The pandemic, the 2020 election, never before have people been paying as much attention to what their government is doing as they have since early 2020. It has been remarkable how government impacts everyone's everyday lives. People are engaged. They are seeing what's happening and they want to see background on how decisions are being made, what is being done at their different local and government agencies. And that's reflected in our appeals and why we saw such an uptick and why we saw an emergence of certain issues being at hand in those requests. So some of the things that we have seen, these are all things that are swirling around social media, in the headlines, talked about with your family and friends. Those tend to be reflected in what we get here. So for example, the impact of COVID and the pandemic. We received hundreds of requests for people wanting information about, or appeals, about mask policy at schools or mask policy at a government facility. The Department of Health used to be barely a blip in our annual report about how many appeals they have received about information. They exploded in terms of the number of appeals because people wanted to understand and see records about the pandemic. And then the 2020 election, there was a lot of discussion about the 2020 election in Pennsylvania was one of the states in the spotlight. And we have seen, again, Department of State used to be kind of a less represented agency, but now it's one we regularly get appeals for records related to that. And also the county election offices have seen quite a lot of records of people interested in that issue. Another one, going back to the schools, just as the pandemic seemed to be quieting down a little bit in terms of our appeals that we see, another issue came up that school districts have received a lot of requests on, and that's on curriculum and content taught in public schools. What is it that is being taught? A lot of people are very interested, as you are probably aware, in what is being taught at public schools. And so there have been a lot of issues that have come up because of that and people wanting to see records related to that. So today we're going to take examples of some of those topics, talk about what kind of information people are hoping to get, what kind of records, and then what's at play when you make a request like that, because it's not always straightforward. It's not always an automatic clearly as to what can be granted and what can be denied in terms of access to records. So just going to go through some of these things and see what we dealt with here as we're dealing with those issues. If you have a question during the chat, during the discussion, feel free to put it in the chat and we will try to get to it. First thing we're going to talk about, COVID policies at schools. We received hundreds of appeals regarding this issue. George, you get a lot of the calls and you deal with a lot of the questions people have. What kind of things were you hearing from people that they wanted to know about?
Yeah, Liz, I think the inquiries that we got here at the office are pretty much reflective of what we also saw with the appeals. People were curious about, how school districts were developing masking policies, deciding whether schools should be closed or not, remote learning and the like. I think because initially the decision-making process was somewhat decentralized. So you could have one district adopting one policy while the neighboring district had something the complete opposite. So it came down to, I think, people questioning the decision-making process. How were the school board directors, the superintendents and the like, making these decisions? What data were they relying on, and so forth? Masking, school closing, remote learning, and also questions about infection rates. People wanted to know, I guess, to back up a little bit, an announcement would come out from a school district because of infection rates at this particular facility were closing. And, maybe just for a day, maybe just for 2 weeks or whatever. But people wanted to know, okay, what is the infection rate? What is the threshold that districts are using to decide to close a school? And, sometimes just for their district, sometimes for several districts for comparative purposes and the like. So I think, basically they're questioning the decision-making process, trying to shed light, obtain records on the discussions that would take place that resulted in some of these decisions being made.
Good. So Nathan, when you look at the appeals that we got are surrounding these issues, what are some of the legal issues that come at play when people are requesting these kind of records?
Well, there's a bunch of different issues and legal exemptions and principles and laws that apply. So I'm just going to work down through them. First off, before we get into talking about those, is the discretion to release records. The right to know law is not a confidentiality statute, which means it allows an agency to withhold records, but it doesn't require them to do so. So the discretion lies with the agency. So in this situation, school districts could release information even though they could withhold it under the right to know law. So there's that aspect to consider as well, that there is that discretion within the agency to release records that they deem fit. Now, obviously that's going to come into play with how other laws might affect that information. Other laws may preclude it, where the right to know law doesn't have an exemption that allows them to withhold it. But generally speaking, with the right to know law itself, that's how that works with the discretion. Another issue that comes up that people are instantly concerned about, and rightfully so, and as a parent, I completely understand this, is you want to protect the privacy of your child. And privacy issues are one of the first ones that come up when we deal with this, whether it be releasing medical records, because we did see requests that tie into medical information of specific students, or maybe a list of students that tested positive. In those situations, and we would see parents trying to file right to know requests, and we've seen this over the years, trying to get information on their child. The right to know law is for everybody. It's a public law. It's the information you're trying to get under that law is public information. So while you may be able to access your children's information and medical records under another law, you're not going to want to do that under the right to know law, because if you do under the right to know law, it would be public to everybody. So we denied, obviously, a lot of those appeals. Privacy became an issue, right to privacy with home addresses, different individuals and people involved, email addresses. Those would be redacted. That would be an issue. We'd also see issues procedurally that would come up, untimely. So, if you're going to be a requester in this situation, make sure you're keeping track of your appeal times. If you don't file it in a timely manner, it's going to get dismissed as being untimely. Premature, make sure you're giving the agency time to respond to you and you're not filing it before the agency's had an opportunity to respond. Getting a little more detailed, we had a number of appeals come in that involved specificity, and that is the requester not making a specific enough requests and not being clear enough as to what records they're trying to get. And that causes issues with the agency, because obviously if they don't get a specific enough request, they don't know where to look for the records. They don't know what records are necessarily being asked for. And this became an issue because a lot of the requests that were generated through COVID and the pandemic were a lot of first-time users for the right to know law. So a lot of times, generally, when you're using it for the first time, your tendency can be to ask overly broad requests for records. But that was another issue that we pointed out. And just to point out, I'll give you an example of a non-specific request. All emails sent to or from the superintendent regarding mask exemptions, mass exceptions, doctor's notes, and orders from August 25th through November 11th of 2021. So that's very broad. Could touch any number of emails to and from somebody. Could involve any number of subject matters, even beyond those that are specified. And that's what specificity looks at, is just generally type of record that you're requesting, the scope. You have to explain what that is. You have to give a subject matter, and you have to give a time frame. So if you're a requester, I mean, that's a very general, quick rundown. But if you are a requester, you have to make sure that you're specific in that approach. And I would encourage you, if you are a requester that uses this, and even an agency, as you're developing your exemptions and maybe use specificity as a reason for denying a request, go and look at some of the court decisions that the court has come down and said that these types of requests are specific enough, because then you can use that as a pattern if you're a requester to develop your request. And if you're an agency, you can use that as a pattern to determine whether or not a certain request is specific. And we have a case law index on our website, which makes it kind of easy to go in and look for those cases, and you can look at them and print them up, and right within those decisions, it'll break down what the requester asked for when they filed their request. We ran into situations where the records just plain did not exist. And in those situations, we looked to the agency to give us an affidavit that indicates that they performed a good faith search. They went and looked where the records would have been stored. They may confirm at times that records were deleted or discarded as part of a retention policy. And then they give us a sworn affidavit or attestation stating that the records do not exist, that they performed this search. And that ends the appeal at that point with respect to those records. Like I said, we looping back and discussing privacy, came up in the constitutional realm. So the constitutional right to privacy tied in with federal laws of the Family Educational Rights and Privacy Act, which is commonly referred to as FERPA. We saw B6 exemptions under the right to know law, which is personal information. And I just want to pause here, and we see a lot of, I don't know how many calls you would get, George, but their parents do call us concerned and email concerned about their child's information, and people very concerned about their personal information over the years getting out there. And with respect to children's information, especially, the right to know law, FERPA, and federal law, I mean, there are safeties built into this. And a person, it's very, very, very unlikely that someone's going to file a right to know request at a school district and get your children's information. And if the school district released it, I would say that is an egregious breach of a right to privacy.
They risk losing their federal funding.
Right. So I say that to alleviate some of the fears that parents and anybody that's watching this as a requester that has that concern. I say that to alleviate your fear that, I've never seen it happen with a right to know request. The school districts and that we've dealt with in Pennsylvania have been very good at citing these exemptions that can allow them to withhold the record. So there's no need to be overly concerned, just cautious in those situations. Another one that we saw come up was in the situation where the school districts would reach out to the Department of Health for information or for statistics, or would provide information and statistics and data. I'm not going to go down the road of talking about Department of Health's records in that respect, but the Department of Health was covered under the Disease Protection and Control Law, and they were under a different guideline than the school districts, and they were able to, as health authorities, not disclose a lot of the different informations and reports that they may maintain, and would instead make those available on a website that even today you can go and access and look at the data that they've accumulated and collected. The Department of Health was an entirely different area of litigation before us with respect to COVID records. Another one that came up is Section 708B10, which is the internal pre-decisional deliberative exception. And that exception allows an agency to withhold records that, as it says, are internal, meaning it's inside the agency, communications back and forth. It's pre-decisional. It occurs before a decision was made. So if you have a situation where emails are sent outside the agency, that's obviously not internal. So those would be subject to the right to know law and could potentially be public if they didn't fall under any other exemptions. They have to be pre-decisional. So if the emails happened after a decision was made about the masks, say, then those would potentially be public if they weren't, subject to other exemptions. And it's deliberative, meaning it was back and forth to reach a decision. You're trying to deliberate and decide what to do. And, we all know there was tons of that going on as school districts and agencies, not just in Pennsylvania, but across the world, really tried to figure out what to do with these policies. Additionally, purely factual information is not exempt in that situation. So purely factual information would be public. So if there's statistical data, reports and studies that they may rely upon that were done by national groups taking looks at different issues within school districts and what the masks mandate should be, and those would potentially be considered purely factual. If we reviewed them and found they were factual, we would order them to be released. B17 was another 708. B17 was another one cited, non-criminal investigative. In these situations, you may have complaints and allegations raised in any number of situations with respect to the masks and the mask mandates and things that were going on in the school districts at that time. If the school district conducted an investigation into any of these complaints or allegations that may have been made, they would, again, potentially be covered under that non-criminal investigative exemption, since school districts have the ability to conduct statutorily the non-criminal investigations. Those would also potentially be actual factual information and could potentially be public in those situations as well, depending on how the data is used and how the information that's collected is used. There was a lot of back and forth, not just within a school district, with boards and superintendents and all of the staff, but also with attorneys. So that brought into play the attorney-client privilege. So many of the school districts reaching out to their solicitors for advice on how to handle the mask mandates and any protocols that they may take or put in place from a legal standpoint, those would be exempt under attorney-client privilege as well. B5, medical records, I kind of touched upon that with the privacy, but there is a specific exemption within the right to know law that allows a agency to withhold records that are a person's medical records. We didn't see as much of those in medical information. We didn't see as much of those tie in specifically where someone said, I want to see so-and-so's medical records, but they did contain medical information. I also mentioned it briefly. B30 has the section 708 B30 is the exemption for a record identifying the name, home address, or date of birth of a child 17 years age or younger. So there's a protection in there for information relating to minors. Another one that came up that was fairly interesting was 708 B12, which is the exemption for notes and working papers. So a agency employee is permitted to withhold from disclosure personal notes that they keep. So if they are in a school board meeting, for example, and a school board official is keeping notes and making notes to themselves about something that they see, or they're prepping for the meeting and make notes, and you file a right to know request for those notes, they could withhold those. Now, the guidance for withholding those is they have to be only used by that person for their personal use. So if they start to share their notes and their impressions from a meeting with other people, or they use it to try to convince or to lead or to even deliberate with other members of the board, then it would potentially move into the public information realm. It would be subject to the right to know law and subject to other exemptions, but those would be governed under that section 708 B12. Those also apply to message slips, routing slips, and other materials which are specifically named in the right to know law. The area we see these coming up typically before COVID was just from regular, commissioner meetings and board meetings like that. But now in this context, we've seen them related to the COVID and to the protocols that they took to address those.
An interesting scenario that I've run across twice now has been requests for aggregated data where the school superintendent or whoever was concerned that given the way the data was presented, someone who was savvy with statistics and computers could make comparisons to specific buildings, to specific class levels, and potentially identify specific students. So it was problematic in that, our position is if it's aggregated data, it should be released. But if it could be sliced and diced to the point where you could identify specific students, then that could be a problem. I'm not sure how they were ever resolved. We didn't hear much after the initial inquiries, but just an interesting situation that we had to deal with. And I can recall two phone calls with having that discussion.
Great. Sticking with school districts, as I mentioned, another issue that has we've seen a lot of appeals on starting late last year was the curriculum and content taught in schools or in teaching materials. That's been something that people have raised some concern about, and some, not just parents, citizens want to see the materials being taught to students, but also specifically we had a lot of appeals regarding trainings that teachers received. George, you want to talk about some of the things you kind of heard, emails and calls with concerns about those issues?
Sure. And it's interesting because I think some of this was exacerbated by the COVID emergency declaration, where you had both the kids at home involved with remote learning, and then the parents were also working from home, teleworking, and kind of looking over the kids' shoulders to make sure that they were in fact paying attention and so forth. And all of this coming forth in, what is commonly referred to now as critical race theory, or, equity and diversity curriculum and the like. And, parents were concerned about some of the stuff they were seeing or some of the stuff that they were hearing about. So taking a greater interest in, okay, what's the school teaching my kids here? And do I in fact agree with it, or do I have a problem with what they're being taught? So we were getting inquiries and seeing requests for, copies of curriculum material, copies of textbooks, and the like. And when you talk about, getting to see textbooks, obviously you're not going to get, under the right to know law, you're not going to be able to copy or get a copy of a textbook because of copyrighted materials. But to be able to go into a school and inspect a textbook or library materials and the like, that was certainly something that we saw a rise in, and presented some interesting logistical problems, especially if these schools were closed. And they're involved with remote learning. The schools are closed to the public in general because of health concerns, but yet how does a parent get to review the materials that schools are using to teach their kids? So there were some logistical issues there. Also, we saw the rise in remote learning, not only for our students, but for teachers as well. So teachers would be involved with workshops, in-service days, where there would be remote learning with experts in the field on these topics, and we'd see requests for copies of those sessions. And whether it be a Zoom meeting, a Skype meeting, or whatever, if it represented a transaction or activity of the district, then it was in fact a public record, and it should be released. So a lot of interesting dynamics with this whole particular topic, and it's somewhat indicative of the, what I'll call the current culture of divisiveness that we're seeing with school districts in particular, where it seems like there's, battle lines formed between the school boards and the parents, and just a lot of complaints about that, a lot of divisiveness, and unfortunately, not every district is responding in a positive way. And I think, many parents also bear responsibility for this as well, with the what I'll just call the heated rhetoric that takes place. And I think that is reflected in many of the inquiries that we've received, right to know requests that we've seen, and many of the appeals.
Great, thank you. Nathan, if you could talk about some of the legal issues that come up with these kind of.
Yeah, a lot of the legal issues that come up in the curriculum and textbooks arena come up, we just discussed in the COVID mitigation. And, the first one, again, being discretion to release. And I encourage agencies and school districts, specifically in these situations where, like George was just saying, there's divisiveness, and there is a hostile environment, so to speak. You have the discretion to release those emails that go back and forth and are technically internal pre-decisional deliberative records, and you can withhold them. but it may be in the public interest and it may be in the best interest of the community at large to be able to see how and why you reached the decision. Obviously, before you would release those type of information, those type of emails, you would want to contact the people that are involved in the emails. But those are the type of extra steps that agencies can take to potentially even avoid more right to know requests by releasing information that they're not necessarily required to release and can withhold if they so choose. Again, just a heads up to requesters to keep track of your time frames when you're filing the right to know appeals. You have from the date of denial or the date of a deemed denial, you have 15 business days to appeal to our office. Specificity, I didn't go to a lot of detail of this. I again, just encourage requesters to think through your requests. Make sure, try to put yourselves in the shoes of the agency, knowing that they're getting, bombarded with a lot of these right to know requests. Be as specific as possible. And in the context of what George was mentioning with aggregate data, and you're trying to get statistical data, reach out to the agency and try to work through with them what statistical data you're looking for. If it's something they can produce, if it's in a database, how they could work with you to try to get you the information you're needed. And again, we emphasized it through the pandemic, common sense and common courtesy, that you be nice and kind when you're trying to work with agencies, and likewise that the agencies be respectful to those who are trying to get information to answer questions that they have. The big difference between, and I'm not going to go back over the various exemptions that apply, because the same will apply here with the investigative, the pre-decisional deliberative. The big difference here being, as George mentioned, the Federal Copyright Act, and that prohibits the agency, the school district, from making copies and distributing them. And it was a big dilemma for the school districts trying to figure out how to allow access to these records. You couldn't take pictures of them and post them for people to look at, because that's a violation of the Copyright Act. And then you're facing the COVID protocols that are in place to allow in-person inspection of the textbook. So it was very challenging. From what I understand, I think most of the agencies worked through it. I know the appeal that some of the appeals we received were situations where the requester declined to go inspect, and the school district had granted access by opening that opportunity to the requester to come inspect them, and that met the agency's burden, and those appeals were denied. It's also worth noting that the agency can set up these schedules to allow you to come in and inspect. That is their prerogative, and their right under the right to know law, that they can work with you to schedule that time. It should be a reasonable process. You're not going to have a school district that says the only time we're going to meet with you is at 7:30 a.m. There needs to be a reasonableness to that back and forth between the requester and the agency to set up that time to review it. The other thing we saw that was interesting was I think one of the school districts, and it wasn't part of an appeal, but I remember having a conversation with somebody that they referenced that they could go and get the book off of Amazon, and that does not meet the burden that the agency has there. You're going to need to set up for that inspection. But that was basically.
Do you know what school books cost these days?
Yeah.
If you could go back up, I think we have a couple questions.
Okay.
Let's see here.
Yeah.
There's one earlier.
Right. I'm going to scroll up and see. There we go. From Katie, I have submitted a right to know recently to my district. I was very specific, wanting any and all communications with Department of Education, Department of Health, on the topic of health and safety and masking. I got the results yesterday, and any of the entities included. Additionally, friends I know who've sent emails, those weren't included. Do I need to appeal?
I don't. We can't give legal advice, but you completely have the opportunity to appeal that within the 15 business days. That constitutes a denial, and in situations like this where the requester is alleging that there are records there, we will, when an appeal is filed, reach out to the agency and ask them to provide us with attestations or affidavits declaring that the records don't exist or that they've provided everything. We also confirm with the agency that they've done a good faith search in looking for the records that may be responsive, and the appeals officer will then make and render a decision in the case based upon the evidence that's submitted by the agency or agencies. And if I would advise, it looks like there's several different agencies in there. Those would be, potentially, if it's just to the district though, yeah, you're just one appeal. I was gonna say, if you file different requests with different agencies, you're gonna want to file appeals for those agencies as well. But if it's just to one, looks like it's just to one district, then you could file one appeal on that one.
Okay, and then from Megan, what happens if an agency requests an extension beyond the 5 business days plus the 30 calendar days? If the requester does not want to agree, can they just file their OOR appeal? Yeah, the answer is yes. The agency has the right to invoke an up to 30 calendar day extension. Anything beyond 30 calendar days, they need the requester's permission. If the requester fails to give that permission, then one of two things happen. The agency either needs to readjust its time frame so that they respond within the 30 days, or they in fact are deemed denying the request once the initial 30-day lapses. So because of that deemed denial, the requester's appeal window opens up at that point if they're not agreeing to the additional extension. Hopefully that addresses what you put there.
And just to build, I mean, it's not necessarily part of the question, but sometimes it comes up, is what happens if the agency is taking the 30-day extension and they're not taking it appropriately? Because there are certain, there's a list of things they can take an extension for. And we haven't decided that issue. It hasn't been really brought up or decided with us or even in the courts, because really by the time you would challenge the 30-day extension, it would have been quicker for you just to allow the agency to take the extension and to move on. So that's just a extension issue that's built into the law that gives them the right basically to take that 30-day extension.
Yeah, 2 quick points to add to that. First off, and we get a lot of complaints about districts, municipalities that automatically invoke the 30 calendar day extension for what appear to be readily available public documents. If an agency can avoid that, please do. Don't get into the habit of just automatically taking the extension, because it upsets a lot of people. And secondly, for the requesters, for your benefit, it is pretty much written in stone that agencies do have that right to take the extension, and to try to appeal that or somehow have that overturned, it just, no one has been successful in doing that.
And even to build on top of that, let's say you get a request for a budget. I mean, budget is one of the most black letter open records, public record that you can have, and you're taking a 30-day extension for that. That could be a situation where the agency could be looking at a finding of bad faith. And if a requester has to take an appeal, that could be something a requester could take to a court to look to get reimbursed for any attorney fees they might incur while they're pursuing that appeal.
Yeah.
All right, changing topics a bit from issues at school districts. The 2020 election, that continues to have a lot of media stories and questions people have about some of the issues that came up and how things were counted. And this one is particularly complex because it involves the state level. Department of State has some role, but also each county has a role. And then Nathan will talk about probably a law that kind of supersedes the right to know law in some regards and trying to get that information. So it is complex, and it is something that is not easy to traverse your first time around. So I would encourage you to listen to the kind of things we talk about, and feel free to reach out if you have questions for us. We can't really give you legal advice, but we might be able to say, you might want to look at this previous decision we did in that. So George, you want to talk about some of the inquiries that we got about that issue?
And you're right. This is both interesting and complex because of allegations made in the media and through different interest groups about potential election fraud in the last election. And without expressing any opinions or findings on that, we received a lot of inquiries. It's like, okay, how do I get voter registration data? How do I get the voting records in and of themselves for a specific municipality? And then we had the focus on voting machines. Were the machines rigged? And how do I get audit data? How do I get inspection data? How do I get any sort of information on who owns these machines, what were the leasing arrangements, et cetera, et cetera. For the most part, every county has an election board, so we would steer people to them. Start there, and then it's also possible, like Liz said, is you may end up with the Pennsylvania Department of State, because it's their responsibility to more or less oversee elections within the Commonwealth.
All right, Nathan, we want to talk about some of the legal issues.
So some of the legal issues that came up, and not to keep beating the drum on specificity, but we see specificity come up a lot, raised by agencies and requesters, again, first-time users or new and learning users, asking these broad, I want all records related to the 2020 election. That you got to narrow it down and be more specific than that. Same thing we saw was with school districts. There are situations where the records just plain do not exist. Either they were never created, either they were discarded or deleted. Again, we look to the agency to give us an affidavit showing they looked for the records and to prove their burden in that respect. There are, as was mentioned by Liz, there's records that fall under a different law, which is the election code. And the election code governs a lot of the access to election records. And I'm not going to bore you by reading it, but the election code breaks down not only what records are public, but it also breaks down how you get access to them. So when we would have a right to know request for, let's say, one of the ones was ballot images. Now, the contents of a ballot box are specifically off limits. We looked at this case and said, ballot images is a picture of the ballot. Seems like that is pretty much the same as the ballot itself. That's exempt under the code. Therefore, we're going to deny access to that. There are also requests for maybe other records that might be public records. It might even say in the election code, this record is public. This is how you get it. Even if you appeal to us, we would say, and we did say this, the record is public under the election code. However, to get access to this record, you're going to have to follow the procedures and the processes set forth in the election code. And the election code will break that down and has different steps that you can take to get to either inspect or to get copies of certain records. There was also intermingling that went on because people would file right to know requests that would involve records that are covered under the election code. They would also include records that were covered under the right to know law. So for example, they might want copies of contracts and emails related to the contracts intermixed with registration lists, voter registration lists, or with ballot images or ballots themselves or copies of other records that are specifically exempt under the election code. We would separate those, break down, here's how you get access to the ones on the election code. With respect to the contracts, those are public records. There may be exempt information within the contracts. We would look to the agency to explain if there's any trade secrets or copyright material contained within the contracts. Typically there's not, but sometimes there may be something attached to a contract that is a trade secret. Agency would have the opportunity to explain that to us, and then the appeals officer would review the evidence that had been submitted and reach a decision as to whether or not those contracts were public. Like I said, most of the time contract information is public. So it was very interesting to go through this, as having handled this over the years. I'm sure you've ran into the same thing advising, talking to people on the phone. Is it's public. We typically grant access and say, agency, you need to release this. And this time we're saying, agency, you need to release it, but you got to follow the other law before doing it. So it was a little bit of a different approach for us than what we're generally used to in referring agencies and requesters to another law. It has come up in other cases that we've dealt with, but I think this was the biggest volume we've had just based on sheer interest in the outcome of the election and all the events that transpired after.
Yeah, I think, it's one of those issues where while the right to know law is very powerful and very useful, occasionally we're going to encounter situations that are just so complex by their nature that not all the answers are there in the right to know law. And it's just one of those things where, it's too sensitive to try and wing it. You need definitive answers. And unfortunately, because there's not really a body of case law that deals with these particular situations, it just proved to be a very difficult exercise for our office.
And even in the situation where you got into investigations being conducted by counties, those are exempt potentially under B-17 as non-criminal investigative records.
Mm-hmm.
And again, I would go back to the, establishing confidence in government, that even though the agency does have the opportunity to withhold those records, it may be in the best interest of everyone to release those records just to show, things are above board, to demonstrate accountability and say, hey, we've done what we're supposed to do. And that can be of a benefit at times.
Yeah, and I think, that you raise a great point that I'll second. And my experience has been in those instances where the agency has chosen to release records that it technically had the discretion to withhold, usually their problems are solved and the environment tends to, become much more calming because everybody recognizes, the pressures that many public officials are under. I think masking policies is a good example where people were focused on school board directors when it came to how masking policies were developed, when in fact they were simply following mandates handed down by the Pennsylvania Department of Health and the Pennsylvania Department of Education. They really had no choice. If they did have a choice, it was whether we're going to follow the law or we're not going to follow the law. I'd hate to be put in that position, but many school district board members were. So I think just to second your point, that if you lean towards transparency as an agency, you're going to solve a lot of your problems because you're sharing the decision-making process and giving people a view into how that process takes place.
And just to add one quick thing,
Try it now.
Hello?
unplug it and plug it back in. It did that to me the other day.
Okay, hold
One
on.
second. For letting us know. That is helpful. I would hate to sit here without you hearing all the amazing things we're saying. All right, so.
Is there any more questions?
Are there any more questions? I didn't see one, unless that Jacqueline.
The last 10 minutes that you.
Yeah,
yeah. What did he say?
Okay.
Uh,
It's what you said at the end, Nathan, which was great. But.
Oh, my what I said at the end when I was just moving my lips was that posting things in advance on your website. So right to know requests are probably going to be coming about certain issues that you're handling, even though you can potentially withhold them. It's a good idea to review them and to the extent you can post them on your website, even though you're permitted to withhold them as pre-decisional or investigative records.
You guys are paying attention. That's great that you knew exactly where Nathan cut off. Yeah, one thing we do here is we get right to know requests for records for our office. And when we grant records, we post those records on our website. So if you are fascinated to know what people want to know about our office and what we provide them, you can go on our website and see exactly what we provided to people. Now that's not something every agency will do, but that's something that, an option people have, or just look at. One thing we have done is, okay, what do we get a lot of requests for? It'll make our lives easier if we just put those on the website so we don't have to continually individually grant access to records. So it is a great thing. And if it's not always something at the top of mind of agencies, so if you occasionally talk to your school district or your local government, you could even mention that to them. Said, hey, have you ever thought about just putting these things on the website? It could go a long way in helping everyone get access to things. So those are the issues we talk about. Before we depart, I just wanted to mention a few legislative trending issues. The right to know law is something that is a law that people pay a lot of attention to. It affects individuals, it affects local agencies, it affects state agencies, it affects companies. And so there's often talk about reforms. And the two that are continuing to be discussed in the legislature, one is what they call the vexatious requesters. And that is kind of a big word to say people who are purposely making lots of right to know requests with the intention to annoy or disrupt an agency. I always say that a 1-year-old cannot be vexatious because they don't know that they're being annoying, but an adult can be vexatious. So some agencies have felt like there are certain people that are just trying to annoy them or cause work, or they have a personal grievance, and they have sought ways to remedy that. How can we, because this is not the purpose of the right to know law. It's not to annoy people. And some states and some other governments have passed laws about this. And the one that's being discussed here is that if a government agency believes that a requester is vexatious, the way it would work was they would appeal to our office and say, we think this person's vexatious. That person would then provide us evidence as to why they think they're not vexatious. We would hear both sides and make a determination, and we could, if we deem them vexatious, say, this individual is not allowed to make any right to know requests just to this agency for up to a year. So kind of like a timeout where they can't do that. So that has passed, I believe, one chamber of the legislature and is in the other one. So time will tell if that becomes law. And the other one, kind of on a similar vein in terms of getting back to the intention of the law, are commercial requesters. Some entities like to get records to help their commercial interests. George, can you think of an example of one? There's pools or people who do.
Oh gosh, there's. Can I name names?
No. Company A.
Yeah, Company A, based in Boca Raton, Florida, along with several other companies that seem to live in that town. I need to visit there one of these days. But yeah, I mean, Liz is correct in that there are primarily out-of-state concerns that will submit right-to-know requests to agencies to get information for free that they will turn around and then sell at a profit. Now, obviously, that's not the intent of the right-to-know law. So there are some, ideas on how to deal with that in the legislature, and our office has always been supportive of that.
The idea is that there could be fees, that if you are a commercial requester, there can be, it's not exorbitant, but some labor fees associated with accessing files, because, like I said, the intention of the right to know law is not its purpose.
Yeah. An interesting aspect to that too is that the commercial requester has to sign an affidavit, I think, or attestation that they are a commercial requester. Mm-hmm. Which I think is kind of an interesting exercise before you even get to the point where the agency can charge fees for the work that they'd have to do. My personal belief is that I think this is going to throw a lot of cold water on those commercial requesters, and they're going to back off.
Jacqueline Fox, if you are trying to type a question, we cannot see it.
All we see are a bunch of emojis, which might be what you're doing there, but just to make sure.
Just in case you're not trying to type something in invisible font.
Yeah.
And then one issue that I've mentioned that is not, there's some legislation, but not a lot now. Another thing that we do in our office is we provide training on the Sunshine Act, which is the Open Meetings Act, which dictates how meetings of local and government agencies must be held in order to make sure that the public has access to what's going on. One thing that the legislature did very well is when things started shutting down in the spring of 2020, they quickly created a law that allowed agencies to conduct their meetings remotely, virtually, so that people don't have to gather in one spot. So they use Zoom or whatever it may be to conduct their meetings. And once the governor's emergency declaration was ended, that law allowing virtual meetings was no more, and it has not been yet replaced. So our interpretation of the Sunshine Act is that you still need to have an in-person component to a meeting. So if you want to add virtual to element to your meeting. You want to Zoom it live or Facebook it live, I'm not sure the words, and you still have to have an ability for people to come in person to an in-person location and ask questions and participate. And that is something that has not changed. There's been talk about it, but to allow a 100% virtual meeting at this point, we believe would require legislation. So that's just one piece that's still not been resolved yet. Okay, Megan had a question. What counts as a commercial requester? Is it a company going to sell the info, or does it also include contractors trying to get inside info?
I think the way the law is phrased, if I remember correctly, is if you're using it to make a profit.
Yeah, which really opens things up, and that would not include news outlets.
Right. News outlets are specifically exempted. Research, I think, is exempted as well. That's something we would look at from a legal viewpoint and a factual component as well, as to determine whether or not the company was going to make a profit or was trying to use the information for commercial purposes. That would be a determination. And looking at it, I mean, if you're trying to get bid info to make a better profit or be able to make better bids, it would seem to imply strongly that would probably fall under the commercial purpose. But there also may be accountability issues with that as well.
Yeah, from a practical perspective, we all complain about, the out-of-state companies from Boca Raton, Florida, but the most common commercial requests really are, from what we've discovered, are the environmental firms that are doing phase 1 reviews for property transfers. They'll send a right-to-know request to a municipality asking for any environmental issues associated with a specific address, because that address has come up for sale or development of some sort. So, there are several approaches you can take. One is that, the sale of that property is going to generate tax revenue for your municipality. So maybe you don't want to charge for it. But if it's something you want to do, you'll have a right to do that, because at the end of the day, that engineering firm is making money on the work that they're doing. They're just, rather than coming into the office and going through the files themselves, they're filing a right to know request. And I happen to know someone who does this for a living, and their response is, well, we'll probably just end up tacking the cost that the agency charges us onto the bill that we give to the the property owners. So there are several approaches that you can take with that. But in specifically defining what is a commercial request, I think that's going to be a challenge. It's going to take a while to work out exactly what is commercial and what's not, because admittedly there are those gray areas. Yeah, it looks like we've got a couple here. I'm going to scroll down, folks, and try to see these other questions. Natalie, we have a blank comment from you, so you might want to double check that.
Oh, Janelle can see the questions. Okay, so I'm sorry, Janelle, go down below. Janelle posted. So Jacqueline's question. Okay, can you talk about the Shannon versus Department of Education case in relation to the Chester Water Authority case? I'm not familiar with the Shannon one.
It's basically what the Chester Water Authority one was, that it's no longer, in the past, emailing contractors that you were working with as an agency or consultants, that was considered to be internal discussions. The court has reversed that and said that no longer is considered internal. So those now would be considered outside emails. They would be subject to the right to know law, and you could look and use other exemptions potentially to withhold those records, but you could no longer use Section 708B10 for those contractors and third-party consultants.
Mm-hmm.
And Shannon versus Department of Education, it's not coming to me.
Yeah.
What's the pre-decisional deliberations and?
Oh, internal versus external.
Yeah.
So that's the Chester Water Authority. Yeah, Francis, your question, what about attorneys? And we call this pre-discovery. And under the right to know law, you can file a right to know request for any reason. And we've determined that discovery is a valid reason. The dilemma is that The right to know law can be both advantageous and disadvantageous when it comes to potential litigation and fact finding. The best we can tell you is that if the case is before a judge and it is in discovery, it's possible that the judge can order limits upon what is open to discovery, and that would also apply to the right to know request, because the right to know law defers to a judge's order. If it hasn't reached that phase yet in litigation, then, really you do the best you can. My recommendation is always reach out to the attorney and see if there's any way you can narrow the scope of the request, because most requesters, their frame of mind is to cast a very broad net, where from the agency perspective, they would like that net to be as narrow as possible. So usually the solution is somewhere in between. There's absolutely nothing preventing you from having a conversation with the requester to try to come to, a reasonable expectation on, just how broad that casting of the net should be. Okay, thank you for the comment on the mic. We'll stop moving it around.
Could you go up again one more time? Keep going up.
Okay, that's
one
the
more
one.
time. One more time.
Sorry.
Keep going. If someone, Janelle, if you could post what Natalie's question was, because that's also coming up blank to us.
Yeah. Okay. Michelle, I just happened to get a request from a Florida company asking for our employee information, wages, hire date. They are saying the purpose is to make them more accessible to the public. Yeah, I know who you're talking about. If that information is already accessible, do I have to provide it? Well, it depends on how it's accessible. If you have it on your agency website, the right to know law allows you to simply provide the URL, universal resource link, to that page on your website, and that is considered a valid response under the right to know law. If it's accessible through some source outside of your agency, you can't rely on that. You have to provide what you have in your possession. Okay, Francis, to clarify, I meant, is an attorney request or pre-discovery request part of the vexatious requester amendment?
It's not specifically mentioned, no. It would be, there'll be some interesting arguments that'll be raised if that legislation should pass. We've talked about it, in advance already around here, just, water cooler talk, and it'll pose some interesting, because Connecticut has this law already, and I would have thought that they would have seen, a decent use of it by agencies, and I think they have less than 5, and they've already had it on the books for 2 or 3 years now. So it's worth watching. Again, pre-discovery is not mentioned, and we'll have to see how that will tie into things. I think it has the vexatious requester by its intent, and I know some of the ones in Connecticut where people were filing 300, 400, 500 right to know requests, the equivalent, in a year, or filing 60 or 70 in a month. That's the type of vexatious requester I know that Connecticut had in mind when they passed theirs.
Yeah, I think that there's just going to have to be a lot of things worked out if that provision is passed. Some of it's going to be fairly objective in establishing numerical thresholds. A good portion of it's just going to be subjective. And what was the intent of the request? Were there any public statements made that are reflective of a vexatious attitude and so forth? And I think it's going to be very tough initially to work it out, because you're basically starting from the ground floor with some very general guidance, and you're going to have to build a body of case law. And when you think about the impact of it, you're taking away a citizen's right to petition his government for a year. So I would think that the definition of vexatious is going to have to be fairly rigorous in order to support taking away that right. It's going to be a very heavy load to carry for a while.
And highlighting off that, obviously if you're taking away a right, you're going to get into constitutional issues, which people have expressed constitutional concerns with the vexatious requester law as well, and we'll have to see how that goes. But and even in a commercial for tomorrow, the pandemic has created so many situations like this where, you know, we're seeing new issues, new paradigms, even on issues that we've handled in the past. With tomorrow's subject is data and the storage of data and how to get that data out of databases, and whether you have to compile it, create it, calculate it. There's all kinds of these types of issues that have come to the forefront because of the pandemic, because citizens have become much more involved with using the right to know law, and that's a good thing and keeps us busy.
Yeah, that's for sure.
Well, that's everything we have. As always, we're available if you have additional questions. You can find our email address and phone number on our website. We like to hear from people, so please feel free to reach out with future questions. Thank you and enjoy the rest of your day.
Take care, folks.
Bye-bye.